for being here today. We appreciate your being here. I think you'll probably find that most of what we go over will be review for the more experienced attorneys, and hopefully for the newer attorneys, just give you some things to think about before you're going into trial and when you want to set yourself up for an appeal if necessary. So we'll just sort of move along quickly, and hopefully there will be lots of time for any questions that anyone might have. So first of all, one of the things you first want to think about is when you're going to be filing for your 355 objections and discovery. And I think what Dennis touched on this in the last training that he did, but I think what we want to consider is nothing should be a knee-jerk reaction. So it should never be just we're waiving time, or we always set no time waivers, or we always file 355 objections or discovery. We really need to look at the facts of the case and determine what makes sense for this case, what's going to help our clients in this case. It's also important to read the code 355. When I was a new attorney, I actually filed 355 objections. Moran might have been on that case, where I was naming police officers in the 355 objections. So obviously that just sort of outed me as not having read the code and not knowing what I was doing. So we've all made mistakes, but I would definitely make sure that you do read the code and you know when someone's covered by 355 and when someone's not. And if you do want that person to be present for cross-examination, you'll be issuing your own subpoenas, obviously. I'm also going to give an example of when I found discovery to be really important and when it was less so. And one is just from yesterday. So I have had 2 failure to thrive cases in the last 2 months. The first failure to thrive case came in because it was actually the hospital that called in the hotline saying this child has failure to thrive. The doctor diagnosed the child with failure to thrive, and yet the mother had been taking the child to the doctor ever since birth, and I made sure we went ahead, we filed that discovery. We wanted to get absolutely everything that the department had as quickly as possible, including Title 20s and any contact that the mother had had with the department. Also, as soon as I got back to the office after picking that case up at arraignment detention, I put in the action request to subpoena the hospital records and the birth records for the child, because I knew that the department was going to get those records, but I didn't know when the department was going to get those records, and I found it to be extremely important that we have that time to review those records. As it happened in that case, we got the 400 pages of Kaiser documents about a week before the department provided them. And one of the beauties of getting Kaiser records is everything is on the computer. So you're actually able to read everything. You don't have to try and decipher doctors' handwriting. I read through 500 pages, 400 or 500 pages of the hospital records. I was tagging and highlighting every contact my client had, the emails that she was sending to the doctor, the fact that this was a woman who was extremely committed to her daughter's health. She was sending emails about questions about dirty diapers. This was just not your typical failure to thrive case. And what happened was, on the day when we got all of these records in, I was talking to the other counsel extremely passionately about this case, saying, well, you have to look at this page and this page and this page. And everyone's asking me, well, how did you get through all these documents so quickly? It was because I got them on my own. And because of the seriousness with which I took the case, because I was able to direct the other attorneys to specific pages in the voluminous records, we were actually able to get the kid home. The department did agree to return the child and to strike the failure to thrive count. We had also subpoenaed Dr. Berkowitz on that case. It was a situation where that she was actually saying that the child did not have the failure to thrive. So it's just an example of the very first time I read that arraignment detention report and I'm talking to the client, I just knew that there were a lot of records, there was a lot going on here, there were a lot of professionals involved that needed to be followed up with. As an example, with the other scenario, yesterday, Tom Picata and I were appointed for a mother and father. It was their first appearance at the jurisdiction disposition hearing. So it was set for trial in Department 408. and it was a 1-count failure to thrive. And it was not very many documents at all. The report was very slim. There was absolutely no hospital records except for immunization records, which showed the child had been immunized. And it had been called in by a case manager at the shelter who was just opining that the child seemed small. And it was weird that the child was in small diapers. So I'm reading this, and I'm thinking this doesn't seem like there's much here. I go and talk to the mom. She wants to go to trial today. I explained to her all of the things that would not be able to get done if we proceeded today. That I would not file 355 objections, I would not be able to subpoena doctor's records, birth records, hospital records. That I wouldn't be able to subpoena the doctor to come in and testify if necessary. But we did have a statement in the report from the doctor who saw the kid in December, who didn't note any concerns, and the child was meeting milestones. And she decided, she said, you know what, I want to go to trial today. I want my baby back. I documented the file as to what the mother wanted. I talked to Mr. Picata. He was on the same page. I quickly prepped the mom for testimony. She was an educated woman who was going to be able to talk very intelligently about how she was feeding her child. The issue here was this family was homeless, and they'd gone to this shelter for some food, but the case manager was just opining and then calling the hotline. So we ended up going to trial that day, which is not the first time I've done that, but I haven't done that very often in my career. And we ended up getting a home of parents disposition. We also made a great record and are appealing the jurisdiction findings. And we're going to talk a little bit more about appeals as we move through our presentation today. But I realized as I was reading through these papers, why would I file 355 objections on this case manager at the shelter? Because, so she can come in and testify that she has some sort of education in child development, that she worked at a failure to thrive clinic, perhaps. She might have all sorts of qualifications that were not documented in the report. So I determined that in fact it was much better to go with the very meager evidence the department had provided in their reports. They have the burden, and why would we give them more time to dig up even more stuff? One of the other things that was in this case was actually, I made a copy. I was really excited about it. So it was on the page 4 of the jurisdiction disposition report, and I made copies for everyone. They noted there was no drug count in the case, but they made a lot about the fact that the child had tested positive for methamphetamine at birth. And the mother had said up and down, no, I didn't use methamphetamine, I did use NyQuil. She was very consistent, I used NyQuil. And so the CSW consulted with PAC-Talk lab tech Mike, and here we all have his phone number. And he reported that yes, hospitals don't verify and confirm whether the patient really does have drugs in their system. And that some over-the-counter meds, such as NyQuil and Sudafed, can trigger a false positive. And other over-the-counter meds can lead to false positives for opiates, methamphetamines, etc. This is why, and I know Dennis had mentioned this in the last training as well, and we're all should be very aware of the fact these hospital tests should not be coming into evidence. I object every single time. I note the fact that on the test they almost always say not to be used for legal purposes. They always come in. I mean, I've never had a bench officer exclude them as coming in. But we need to make the record, because if you have a client who is consistent, who's saying, I used over-the-counter medication, you make the record that the hospital test should come in, and then call Mike from PAC Talks. Yes, Julia.
I've also had success in calling the labs from the hospital. I got a dismissal after I called the hospital lab and said, is this a positive or negative test? And actually, they told me it wasn't even positive. They had a negative confirmation.
Sometimes they do a confirmation.
Fantastic.
Sometimes there is a confirmation that they don't, that if you actually get the records from the hospital, you can get the confirmation test that the department doesn't have, which is then negative. I did have a case like that.
Which is also goes to why it is so important to get those hospital records if you don't have something like this from the department. The other important thing about this case, which I did yesterday and which is on this photocopy, is that they had the mother test for Pacific toxicology, which is considered the gold standard in testing. And it's important to note that we're not talking about, NyQuil's not going to give you a false positive for methamphetamine with a Pacific toxicology test. So for the newer attorneys, just to be aware of that, I have gotten, I wouldn't say burned, but I have wasted some money talking to John Truding, one of our experts, talking to him for a long time about can Sudafed give you a false positive and this and that. He said no, it can't. We had to pay him for that information, and then the client acknowledged that she relapsed. So we're not talking about Pacific toxicology. We're talking about those unconfirmed hospital tests, and it's something that needs to be considered. Now, most of the time, what I have found is, unfortunately, many clients do make admissions in the hospital. So we have that hospital test and the client saying, yeah, I relapsed. So obviously this is not for that situation. Additionally, any time, or if the client is saying someone spiked my drink, which of course is a possibility, but it's a lot harder to argue that. That situation is going to be the nexus issue, which we're going to talk about with the published and unpublished cases. So do you want to move on to the nexus?
Sure.
And then we'll talk about the agreement.
Okay. So do you want to do the unpublished, or do you want me to do the published?
You start first.
Okay. Okay. So we're going to discuss some.
Shout a little bit louder because back here really can't hear you.
Sure. Now can you hear me? Yeah? No, seriously, can you hear me? Okay. No?
Just yell.
Okay. So there was a handout with 4 published cases, and then I also had another handout that outlined Rebecca C. in particular. So the 4 main published opinions that we're relying on are Rebecca C., which was Emily's case, and it's a reversal out of Judge Cortez, and it's Division 8. There's Drake M., that was Lori Davis's case at a Division 3 from Marpet. There's Destiny S. out of Division 1, and that was a reversal out of Martinez, Carolina Villamil's case. And then another one out of Orange County, which was David M. So the Rebecca C. case is the most recent from 2014. And I think what's most important from Rebecca C., it really talks about causation and harm, because the court found jurisdiction based on mother's history of substance abuse, and that she was incapable of providing for her 13-year-old daughter based on her drug abuse. And the Court of Appeal reversed, finding that while there was substantial evidence to support substance abuse, so the substance abuse fact wasn't really at issue, and the facts actually, surprisingly, are really not that great. Mother had tested positive for meth and amphetamines and marijuana soon after the case was filed, or just before the case was filed. She admitted to a recent relapse. There was prior DCFS history with SIBS, and there was a criminal history. But the Court of Appeal found that the evidence did not support a finding that mother's substance abuse caused a substantial risk of harm to her 13-year-old child. The home was clean, free of hazards, there was sufficient food. The minor denied any abuse or harm. She wasn't fearful of her mother. She was up to date on medical and dental. She was going to school, even though there was some evidence that she wasn't, mother wasn't keeping on top of the homework assignments. So the 2 or 3 takeaways from this opinion is that regarding the school, because a lot of times you'll have issues about There are these kind of vague allegations that the child was tardy or her homework wasn't always submitted on time. But the Court of Appeal found that if a parent's failure to keep on top of a teenage child's homework assignments is sufficient to show physical harm, many parents would be subject to DCFS intervention. So just remember that, that in and of itself is not enough, and it does not rise to the level of physical harm that's required under the code. And also, the Court of Appeal said substantial risk of harm cannot merely be presumed because of a parent's drug use or even because of their abuse. That would eliminate the requisite elements of causation and harm and would in essence shift the burden to the parent to prove a negative, basically to show an absence of harm. And that is not what the dependency law provides. So some of you are in more challenging courtrooms in terms of county councils where they will couch their argument so that it seems to then shift the burden of proof to the parent. And try to remain focused on what the issues are and who has the burden of proof, and make sure that you educate the court, if you have a new bench officer, that it's the department who has the burden of proof to show substantial harm. It's not the parent who has to show the absence of harm, because there is no presumption of substantial harm, even with drug abuse. And be selective in your cases. You want to really assess the facts of a particular case, but this is an excellent case, especially because it's out of, LA County. And just kind of keep focused on that, because I know a lot of newer attorneys with more seasoned county counsel, the county counsel will try to manipulate the burden of proof, and then you feel like, what do I do? Well, what you do is you throw that back in their court to make them prove by substantial evidence what the allegations of the petition are. Drake M. is a case that preceded Rebecca C. So this was a 2012 case where the court found that father's use of medical marijuana did not constitute abuse, and it was not a basis for jurisdiction. They really went into an in-depth discussion between abuse and substance use. But one of the important facts to distinguish Drake M is that this child was very young. It was only a 14-month-old child. And the court did find that father did not fail to fulfill any of his work obligations, his obligations as a responsible parent. There were no risk factors, but the court did say that if the parent was a substance abuser, it would have been prima facie evidence that he was unable to provide care for a 14-month-old child. So remember, in Rebecca C., we're talking about a 13-year-old, so you really have to be cognizant of the age of the child. In Destiny S., which was also a 2012 case out of Division I, and Division I is one of our most favorable divisions, they also said parental substance abuse in itself cannot be the basis for jurisdiction. And there must be you have to show this current risk of serious physical harm. The child in Destiny S was 11, so a little bit more like Rebecca C. And again, although mother admitted to using drugs, tested positive for drugs early in the case, by the time of the juris dispo, she was testing negative. And the Court of Appeal found that the record lacked any evidence of current risk. The minor was happy and healthy. The mother took good care of her. The child again denied any abuse. The school principal had no concerns, even though the previous year the minor had these repeated tardinesses. And so the court addressed that school issue and said tardiness to school in the prior year cannot support a finding of substantial risk of serious physical harm, nor can a decade-old allegation regarding the mother's conduct when the child was a baby. Because there was an issue as to mother's history when this child was a baby, but there wasn't anything current. And one of the really good quotes, which is not in this handout, but it is in the case, the Court of Appeal addressed County Council's concern that the minor said that she could often smell marijuana at times. The court said there was no evidence that the minor was at imminent risk of physical harm caused by the mother's marijuana use, and that the logic of that consequence would be to remove all minors from the homes of all smokers in LA County, regardless of what they smoke, and there was no legal support for that proposition. So Division 1 is very pragmatic and really takes a practical approach to the a lot of the department's arguments that just don't make common sense. So don't be afraid to make common sense arguments to make a record, because often, depending upon what division the appeal will go to, that division will pay attention to that argument, especially if there's no legal support and they're just making this argument just because they have nothing else. David M. is an interesting case because it also talks about mental illness in addition to substance abuse. So the court said just because the parents have mental health issues and or substance abuse problems, there also has to be some kind of causation shown. And here the kids were young. They were 2 and a newborn. And the records all show that the minors were healthy, their home was clean, they were loved, they were not harmed in any way. But the Orange County agency pretty much relied on the fact that a prior petition had been sustained on an older sibling, and they found that just because of that fact, with no current risk, they could not sustain a J count without evidence of specific defined risk of harm to either minor resulting from the parent's mental illness or the mother's substance abuse. And it went so far as to say it is possible to identify many possible harms that could come to pass, but without more evidence, such harms are only speculative. So remember to make sure that there are defined specific risks, because the best thing is just to have, kind of like what Emily was saying, is the less specificity you have, the better it is for your argument. And sometimes giving the department more time to gather more specific facts will only hurt you, and it may be better just to push forward on these vague accusations, because case law provides vague, specific concerns. And again, often, I know often, especially with the minors' attorneys, they're just saying, well, I have concerns. I have concerns because mom's not on top of the kids' homework, and I have concerns because of this. They're really general and vague, and they're not articulating specific, defined risks, and that is what the law requires. So the more assertive you can be in making the minors be specific, I think the more beneficial, your case will look a lot more, will look stronger to the court if you show that the department doesn't have the facts to support the allegations. So those are the 4, I mean, there are other cases too, but these are 4 really strong nexus cases.
So I went ahead and I printed out 2 of the cases unpublished that where I got Soto reversed out of 408, and I also did a little bit of a cheat sheet. So now, as everybody knows, you cannot cite an unpublished case, but you can read them and use the argument and the reasoning of the court. And I thought that these 2 were just interesting examples of how the Court of Appeal looked at these issues. With In Re DS, that was one of the first cases I did in 408. The case came in, it was 2 older parents, they were heavy marijuana users, and they had 2 8-month-old twins. They were really committed to using marijuana. They were committed to their right to use marijuana. They had the cards, they had 420 tattoos, and they came in and they wanted, but they wanted their kids back. And I read the facts. These kids, they were chubby, they were overweight, but not dangerously so. They were up to date on their immunizations, going to the doctor, all good reports from the doctor. There was a dirty home, but it wasn't so horrible. They did plead a dirty home count as well. But the department came in, the call came in because people smelled marijuana coming from their apartment. So that was the call to the hotline. They came in, the social workers were overwhelmed by the smell of marijuana. And the parents were very clear. They said, you know, we take turns smoking. We don't smoke at the same time with the kids. The kids are 8 months old, and this was interesting because we often look at the ages of the children. Now, DS talks very clearly about how the tender years, which we're now seeing in all of the allegations, the children are of such tender years. Well, there's a tender years presumption, but it's a rebuttable presumption. And In Re DS talks about here that was rebutted. The tender years presumption is sufficient only if unrebutted. So you're always going to want to rebut it with the fact that these kids were well taken care of, no marks or bruises, they were bonded to the parents. And the other interesting thing is that the Court of Appeals said that the children were not old enough to be at risk of grabbing and using the drugs themselves. So there's an argument where normally we're looking towards older kids to say that there's less of a risk and they're school age. Well, here we can argue with the non-mobile children that they're not, you know, even if the drugs are being held in a bathroom drawer, as long as they're above where the child can reach, the kid's not going to be reaching in and grabbing them. This is also a case I love because Marlene told me I was going to lose. And she also told me I was not going to win the appeal. So she was only right once. I was really excited about it. So it was, like I said, it was a no time waiver. We appealed. Now, the other thing that I think is really interesting is that this was out of Division 2. The Minors Council and the Mothers Council appealed, and the Fathers Council did not appeal. The Division 2 reversed jurisdiction in its entirety, even for an allegation that only talked about the father. And so those people get to leave this court system. They did reunify with their kids at the 2&E. So they did have their children in their care when the case was reversed. But now there's no 364 on calendar. They don't have the social workers coming into their lives. They're kind of off on their own doing what they're doing. The other, and that case also talks about secondhand marijuana smoke, and said that the secondhand marijuana smoke and the untidiness of the apartment was not sufficient to support risk. So that's just interesting to note. Now, the other case, which is on the other side, and I also printed that unpublished case, In Re Mary Jane R., that was primarily domestic violence and alcohol allegations. And the trial court sustained all of the allegations, ordered the kids suitably placed. I was the only one to appeal, the mother's attorney, and unfortunately, Division 4 reversed jurisdiction and dispo as to mother only, even though the facts and the allegations were identical for the father. And the problem with that for the case is that we still have the 364 hearing on calendar, and the social workers are still giving my client grief. And there's no doubt in my mind that if the father had appealed, the entire case would be out of the system. So obviously you're not going to be appealing every case, but you do want to assess when you feel that you have a righteous appeal, and then definitely talk to the other parents' counsel. You can't make them file an appeal, and of course you're going to file the appeal if you feel it's appropriate for your client. But in this case, unfortunately, the mother told me that the father somehow thought that he was covered by her appeal. So obviously you just want to be having those conversations with your clients. And now I will also, if the parents are getting along or they're somehow aligned, I will say to my client, we're filing this appeal for you, but if the father wants to appeal, he needs to file his own appeal.
And you may want to have a conversation with co-counsel about
Yes.
both filing the notices of appeal, and even Minor's attorney if Minors were on board.
I do think it really helped us with In Re DS that the Minors Council filed an appeal as well. So I've definitely started talking more to Minors Council about that.
Who was that?
They're no longer with us, with Ladle. They made really good records, they just didn't